Section 11 of the Rise and Fall of the Confederate Government, Volume 1A. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. This recording is by Mark Smith of Simpsonville, South Carolina. The Rise and Fall of the Confederate Government by Jefferson Davis, Volume 1A, Part 2, The Constitution, Chapter 1. Contents: The Original Confederation, Articles of Confederation and Perpetual Union, Their Inadequacy Ascertained, Commercial Difficulties, The Conference at Annapolis, Recommendation of a General Convention, Resolution of Congress, Action of the several States, Conclusions drawn therefrom. When certain American colonies of Great Britain, each acting for itself, although in concert with the others, determined to dissolve their political connection with the mother country, they sent their representatives to a general congress of those colonies, and through them made a declaration that the colonies were, and of right ought to be, free and independent States. As such they contracted an alliance for their common defense, successfully resisted the effort to reduce them to submission, and secured the recognition by Great Britain of their separate independence, each State being distinctly recognized under its own name, not as one of a group or nation. That this was not merely a foreign view is evident from the second of the Articles of Confederation between the States, adopted subsequently to the Declaration of Independence, which is in these words: "Each State retains its sovereignty, freedom, and independence, and every power, jurisdiction, and right, which is not by this Confederation expressly delegated to the United States in Congress assembled." These Articles of Confederation and Perpetual Union between the States, as they were styled in their title, were adopted by 11 of the original States in 1778, and by the other 2 in the course of the 3 years next ensuing, and continued in force until 1789. During this period the central government was vested in the Congress alone, in which each State, through its representatives, had an equal vote in the determination of all questions whatever. The Congress exercised all the executive as well as legislative powers delegated by the States. When not in session, the general management of affairs was entrusted to a Committee of the States, consisting of 1 delegate from each State. Provision was made for the creation, by the Congress, of courts having a certain specified jurisdiction in admiralty and maritime cases, and for the settlement of controversies between 2 or more States in a mode specifically prescribed. The government thus constituted was found inadequate for some necessary purposes, and it became requisite to reorganize it. The first idea of such reorganization arose from the necessity of regulating the commercial intercourse of the States with one another and with foreign countries, and also of making some provision for payment of the debt contracted during the War for Independence. These exigencies led to a proposition for a meeting of commissioners from the various States to consider the subject. Such a meeting was held at Annapolis in September, 1786, but as only 5 States, New York, New Jersey, Delaware, Pennsylvania, and Virginia, were represented, the commissioners declined to take any action further than to recommend another convention, with a wider scope for consideration. As they expressed it, it was their "unanimous conviction that it may essentially tend to advance the interests of the Union, if the States, by whom they have been respectively delegated, would themselves concur, and use their endeavors to procure the concurrence of the other States, in the appointment of commissioners, to meet at Philadelphia on the 2d Monday in May next, to take into consideration the situation of the United States, to devise such further provisions as shall appear to them necessary to render the Constitution of the Federal Government adequate to the exigencies of the Union, and to report such an act for that purpose to the United States in Congress assembled, as, when agreed to by them, and afterward confirmed by the legislatures of every State, will effectually provide for the same." It is scarcely necessary to remind the well-informed reader that the terms "Constitution of the Federal Government," employed above, and "Federal Constitution," as used in other proceedings of that period, do not mean the instrument to which we now apply them, and which was not then in existence. They were applied to the system of government formulated in the Articles of Confederation. This is in strict accord with the definition of the word "Constitution" given by an eminent lexicographer. Dr. Worcester. "The body of fundamental laws, as contained in written documents or prescriptive usage, which constitute the form of government for a nation, state, community, association, or society." This definition is very good as far as it goes, but the "form of government" is a phrase which falls short of expressing all that should be comprehended. Perhaps it would be more accurate to say, "which constitute the form, define the powers, and prescribe the functions of government," etc. The additional words would make the definition more complete. Thus we speak of the British Constitution, which is an unwritten system of prescriptive usage; of the Constitution of Massachusetts or of Mississippi, which is the fundamental or organic law of a particular State embodied in a written instrument; and of the Federal Constitution of the United States, which is the fundamental law of an association of States, at first as embraced in the Articles of Confederation, and afterward as revised, amended, enlarged, and embodied in the instrument framed in 1787, and subsequently adopted by the various States. The manner in which this revision was effected was as follows. Acting on the suggestion of the Annapolis Convention, the Congress, on the 21st of the ensuing February, 1787, adopted the following resolution: "Resolved, that in the opinion of Congress, it is expedient that, on the second Monday in May next, a convention of delegates, who shall have been appointed by the several States, be held at Philadelphia, for the sole and express purpose of revising the Articles of Confederation, and reporting to Congress and the several legislatures such alterations and provisions therein as shall, when agreed to in Congress and confirmed by the States, render the Federal Constitution adequate to the exigencies of government and the preservation of the Union." The language of this resolution, substantially according with that of the recommendation made by the commissioners at Annapolis a few months before, very clearly defines the objects of the proposed convention and the powers which it was thought advisable that the States should confer upon their delegates. These were, solely and expressly, as follows: 1. To revise the Articles of Confederation with reference to the situation of the United States. 2. To devise such alterations and provisions therein as should seem to them requisite in order to render the Federal Constitution, or Constitution of the Federal Government, adequate to the exigencies of the Union, or the exigencies of the government and the preservation of the Union. 3. To report the result of their deliberations, that is, the alterations and provisions which they should agree to recommend, to Congress and the legislatures of the several States. Of course, their action could only be advisory until ratified by the States. The Articles of Confederation and Perpetual Union, under which the States were already united, provided that no alteration should be made in any of them, unless such alteration be agreed to in a Congress of the United States and afterward confirmed by the legislatures of every State. The legislatures of the various States, with the exception of Rhode Island, adopted and proceeded to act upon these suggestions by the appointment of delegates, some of them immediately upon the recommendation of the Annapolis commissioners in advance of that of the Congress, and the others in the course of a few months after the resolution adopted by Congress. The instructions given to these delegates in all cases conformed to the recommendations which have been quoted, and in one case imposed an additional restriction or limitation. As this is a matter of much importance, in order to a right understanding of what follows, it may be advisable to cite in detail the action of the several States. The General Assembly of Virginia, after reciting the recommendation made at Annapolis, enacted, "that 7 commissioners be appointed by joint ballot of both Houses of Assembly, who, or by any 3 of them, are hereby authorized, as deputies from this Commonwealth, to meet such deputies as may be appointed and authorized by other States, to assemble in convention at Philadelphia, as above recommended, and to join with them in devising and discussing all such alterations and further provisions as may be necessary to render the Federal Constitution adequate to the exigencies of the Union, and in reporting such an act for that purpose to the United States in Congress, as, when agreed to by them, and duly confirmed by the several States, will effectually provide for the same." The Council and Assembly of New Jersey issued commissions to their delegates to meet such commissioners as have been, or may be, appointed by the other States of the Union, at the city of Philadelphia, in the Commonwealth of Pennsylvania, on the 2d Monday in May next, "for the purpose of taking into consideration the state of the Union as to trade and other important objects, and of devising such other provisions as shall appear to be necessary to render the Constitution of the Federal Government adequate to the exigencies thereof." The act of the General Assembly of Pennsylvania constituted and appointed certain deputies, designated by name, "with powers to meet such deputies as may be appointed and authorized by the other States, and to join with them in devising, deliberating on, and discussing all such alterations and further provisions as may be necessary to render the Federal Constitution fully adequate to the exigencies of the Union, and in reporting such act or acts for that purpose to the United States in Congress assembled, as, when agreed to by them and duly confirmed by the several States, will effectually provide for the same." The General Assembly of North Carolina enacted that commissioners should be appointed by joint ballot of both Houses, "to meet and confer with such deputies as may be appointed by the other States, for similar purposes, and with them to discuss and decide upon the most effectual means to remove the defects of our Federal Union, and to procure the enlarged purposes which it was intended to effect; and that they report such an act to the General Assembly of this State, as, when agreed to by them, will effectually provide for the same." In the case of this State alone, nothing is made of a report to Congress. Neither North Carolina nor any other State, however, fails to make mention of the necessity of a submission of any action taken to the several States for ratification. The commissions issued to the representatives of South Carolina by the Governor refer to an act of the legislature of that State authorizing their appointment, "to meet such deputies or commissioners as may be appointed and authorized by other of the United States," at the time and place designated, and to join with them, "in devising and discussing all such alterations, clauses, articles, and provisions as may be thought necessary to render the Federal Constitution entirely adequate to the actual situation and future good government of the Confederate States," and to "join in reporting such an act to the United States in Congress assembled, as, when approved and agreed to by them, and duly ratified and confirmed by the several States, will effectually provide for the exigencies of the Union." In these commissions the expression "alterations, clauses, articles, and provisions" clearly indicates the character of the duties which the deputies were expected to discharge. The General Assembly of Georgia ordained the appointment of certain commissioners, specified by name, who were "authorized, as deputies from this State, to meet such deputies as may be appointed and authorized by other States, to assemble in convention at Philadelphia, and to join with them in devising and discussing all such alterations and further provisions as may be necessary to render the Federal Constitution adequate to the exigencies of the Union, and in reporting such an act for that purpose to the United States in Congress assembled, as, when agreed to by them, and duly confirmed by the several States, will effectually provide for the same." The authority conferred upon their delegates by the Assembly of New York and the General Court of Massachusetts was in each case expressed in the exact words of the advisory resolution of Congress. They were instructed to meet the delegates of the other States "for the sole and express purpose of revising the Articles of Confederation, and reporting to Congress and to the several legislatures such alterations and provisions therein as shall, when agreed to in Congress, and confirmed by the several States, render the Federal Constitution adequate to the exigencies of the Union." The General Assembly of Connecticut designated the delegates of that State by name, and empowered them, in conference with the delegates of other States, "to discuss upon such alterations and provisions, agreeable to the general principles of republican government, as they shall think proper to render the Federal Constitution adequate to the exigencies of the government and the preservation of the Union," and "to report such alterations and provisions as may be agreed to by a majority of the United States in convention, to the Congress of the United States and to the General Assembly of this State." The General Court of New Hampshire authorized and empowered the deputies of that State, in conference with those of other States, "to discuss and decide upon the most effectual means to remedy the defects of our Federal Union, and to procure and secure the enlarged purposes which it was intended to effect," language almost identical with that of North Carolina, but like the other States in general, instructed them to report the result of their deliberations to Congress for the action of that body and subsequent confirmation by the several States. The delegates from Maryland were appointed by the General Assembly of that State, and instructed "to meet such deputies as may be appointed and authorized by any other of the United States, to assemble in convention at Philadelphia, for the purpose of revising the Federal system, and to join with them in considering such alterations and further provisions," etc., the remainder of their instructions being in the same words as those given to the Georgia delegates. The instructions given to the deputies of Delaware were substantially in accord with the others, being almost literally identical with those of Pennsylvania, but the following proviso was added: "So, always and provided, that such alterations or further provisions, or any of them, do not extend to that part of the 5th article of the Confederation of the said States, finally ratified on the 1st day of March, in the year 1781, which declares that, in determining questions in the United States in Congress assembled, each State shall have one vote." Rhode Island, as has already been mentioned, sent no delegates. From an examination and comparison of the enactments and instructions above quoted, we may derive certain conclusions, so obvious that they need only to be stated. 1. In the first place, it is clear that the delegates to the Convention of 1787 represented not the people of the United States in mass, as has been most absurdly contended by some political writers, but the people of the several States as States, just as in the Congress of that period, Delaware, with her 60,000 inhabitants, having entire equality with Pennsylvania, which had more than 400,000, or Virginia, with her 750,000. 2. The object for which they were appointed was not to organize a new government, but, solely and expressly, to amend the Federal Constitution already existing, in other words, to revise the Articles of Confederation and to suggest such alterations or additional provisions as should be deemed necessary to render them adequate to the exigencies of the Union. 3. It is evident that the term Federal Constitution, or its equivalent, Constitution of the Federal Government, was as freely and familiarly applied to the system of government established by the Articles of Confederation, undeniably a league or compact between States expressly retaining their sovereignty and independence, as to that amended system which was substituted for it by the Constitution that superseded those Articles. 4. The functions of the delegates to the convention were, of course, only to devise, deliberate, and discuss. No validity could attach to any action taken unless and until it should be afterward ratified by the several States. It is evident also that what was contemplated was the process provided in the Articles of Confederation for their own amendment: first, a recommendation by the Congress, and afterward, ratification by the legislatures of every State before the amendment should be obligatory upon any. The departure from this condition, which actually occurred, will presently be noticed. End of Part 2, Chapter 1 of The Rise and Fall of the Confederate Government, Volume 1A.
Of The Rise and Fall of the Confederate Government, Volume 1A. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Bill Moseley. The Rise and Fall of the Confederate Government by Jefferson Davis, Volume 1A, Part 2, Chapter 2. The Convention of 1787. Diversity of opinion. Luther Martin's account of the three parties. The question of representation. Compromise effected. Mr. Randolph's resolutions. The word national condemned. Plan of government framed. Difficulty with regard to ratification and its solution. Provision for secession from the Union. Views of Mr. Gerry and Mr. Madison. False interpretations. Close of the convention. When the convention met in Philadelphia in May, 1787, it soon became evident that the work before it would take a wider range and involve more radical changes in the Federal Constitution than had at first been contemplated. Under the Articles of Confederation, the general government was obliged to rely upon the governments of the several States for the execution of its enactments. Except its own officers and employees, and in time of war the Federal Army and Navy, it could exercise no control upon individual citizens. With regard to the States, no compulsory or coercive measures could be employed to enforce its authority in case of opposition or indifference to its exercise. This last was a feature of the Confederation, which it was not desirable nor possible to change, and no objection was made to it. But it was generally admitted that some machinery should be devised to enable the general government to exercise its legitimate functions by means of a mandatory authority operating directly upon the individual citizens within the limits of its constitutional powers. The necessity for such provision was undisputed. Beyond the common ground of a recognition of this necessity, there was a wide diversity of opinion among the members of the convention. Luther Martin, a delegate from Maryland, in an account of its proceedings, afterward given to the legislature of that state, classifies these differences as constituting three parties in the convention, which he describes as follows: "One party whose object and wish it was to abolish and annihilate all state governments, and to bring forward one general government over this extensive continent of a monarchical nature, under certain restrictions and limitations. Those who openly avowed this sentiment were, it is true, but few, yet it is equally true that there was a considerable number who did not openly avow it, who were, by myself and many others of the convention, considered as being in reality favorers of that sentiment. The second party was not for the abolition of the state governments, nor for the introduction of a monarchical government under any form, but they wished to establish such a system as could give their own states undue power and influence in the government over the other states. A third party was what I considered truly federal and republican. This party was nearly equal in number with the other two, and was composed of the delegates from Connecticut, New York, New Jersey, Delaware, and in part from Maryland, also of some individuals from other representations. This party were for proceeding upon terms of federal equality. They were for taking our present federal system as the basis of their proceedings, and as far as experience had shown that other powers were necessary to the federal government, to give those powers. They considered this the object for which they were sent by their states, and what their states expected from them." In his account of the second party above described, Mr. Martin refers to those representatives of the larger states who wished to establish a numerical basis of representation in the Congress, instead of the equal representation of the states, whether large or small, which existed under the Articles of Confederation. There was naturally much dissatisfaction on the part of the greater states, Virginia, Pennsylvania, North Carolina, and Massachusetts, whose population at that period exceeded that of all the others combined, but which in the Congress constituted less than one-third of the voting strength. On the other hand, the smaller states were tenacious of their equality in the Union. Of the very smallest, one, as we have seen, had sent no representatives to the convention, and the other had instructed her delegates unconditionally to insist upon the maintenance of absolute equality in the Congress. This difference gave more trouble than any other question that came before the convention, and for some time threatened to prove irreconcilable and to hinder any final agreement. It was ultimately settled by a compromise. Provision was made for the representation of the people of the states in one branch of the federal legislature, the House of Representatives, in proportion to their numbers; in the other branch, the Senate, for the equal representation of the states as such. The perpetuity of this equality was furthermore guaranteed by a stipulation that no state should ever be deprived of its equal suffrage in the Senate without its own consent. [Footnote 31: Constitution, Article 5.] This compromise required no sacrifice of principle on either side, and no provision of the Constitution has in practice proved more entirely satisfactory. It is not necessary, and would be beyond the scope of this work, to undertake to give a history of the proceedings of the convention of 1787. That may be obtained from other sources. All that is requisite for the present purpose is to notice a few particulars of special significance or relevancy to the subject of inquiry. Early in the session of the convention, a series of resolutions was introduced by Mr. Edmund Randolph of Virginia, embodying a proposed plan of government, which were considered in committee of the whole House, and formed the basis of a protracted discussion. The first of these resolutions, as amended before a vote was taken, was in these words, "Resolved, that it is the opinion of this committee that a national government ought to be established, consisting of a supreme legislative, executive, and judiciary." This was followed by other resolutions, 23 in all, as adopted and reported by the committee, in which the word national occurred 26 times. The day after the report of the committee was made, Mr. Ellsworth, of Connecticut, moved to strike out the words national government in the resolution above quoted, and to insert the words government of the United States, which he said was the proper title. He wished also the plan to go forth as an amendment of the Articles of Confederation. That is to say, he wished to avoid even the appearance of undertaking to form a new government instead of reforming the old one, which was the proper object of the convention. This motion was agreed to without opposition, and as a consequence the word national was stricken out wherever it occurred, and nowhere makes its appearance in the Constitution finally adopted. Footnote 32. See Eliot's Debates, Volume 5, page 214. This reference is taken from The Republic of Republics, Part 3, Chapter 7, page 217. This learned, exhaustive, and admirable work, which contains a wealth of historical and political learning, will be freely used, by kind consent of the author, without the obligation of a repetition of special acknowledgment in every case. A like liberty will be taken with the late Dr. Bledsoe's masterly treatise on the Right of Secession, published in 1866, under the title, "Is Davis a Traitor, or was Secession a Constitutional Right?" The prompt rejection after introduction of this word national is obviously much more expressive of the intent and purpose of the authors of the Constitution than its mere absence from the Constitution would have been. It is a clear indication that they did not mean to give any countenance to the idea which, scotched not killed, has again reared its mischievous crest in these latter days, that the government which they organized was a consolidated nationality instead of a confederacy of sovereign members. Continuing their great work of revision and reorganization, the convention proceeded to construct the framework of a government for the Confederacy, strictly confined to certain specified and limited powers, but complete in all its parts, legislative, executive, and judicial, and provided with the means for discharging all its functions without interfering with the sovereignty, freedom, and independence of the constituent states. All this might have been done without going beyond the limits of their commission, "to revise the Articles of Confederation," and to consider and report such "alterations and provisions," as might seem necessary to "render the Federal Constitution adequate to the exigencies of government and the preservation of the Union." A serious difficulty, however, was foreseen. The 13th and last of the aforesaid articles had this provision which has already been referred to. The articles of this Confederation shall be inviolably observed by every State, and the Union shall be perpetual, nor shall any alteration at any time hereafter be made in any of them, unless such alteration be agreed to in a Congress of the United States, and be afterward confirmed by the legislatures of every State. It is obvious from an examination of the records, as has already been shown, that the original idea in calling a convention was that their recommendations should take the course prescribed by this article: first, a report to the Congress, and then, if approved by that body, a submission to the various legislatures for final action. There was no reason to apprehend the non-concurrence of Congress, in which a mere majority would determine the question, but the consent of the legislatures of every State was requisite in order to final ratification, and there was serious reason to fear that this consent could not be obtained. Rhode Island, as we have seen, had declined to send any representatives to the convention. Of the 3 delegates from New York, 2 had withdrawn, and other indications of dissatisfaction had appeared. In case of the failure of a single legislature to ratify, the labors of the convention would go for naught, under a strict adherence to the letter of the article above cited. The danger of a total frustration of their efforts was imminent. In this emergency, the convention took the responsibility of transcending the limits of their instructions, and recommending a procedure which was in direct contravention of the letter of the Articles of Confederation. This was the introduction of a provision into the new Constitution that the ratification of 9 States should be sufficient for its establishment among themselves. In order to validate this provision, it was necessary to refer it to authority higher than that of Congress and the State legislatures, that is, to the people of the States assembled by their representatives in convention. Hence it was provided, by the 7th and last article of the new Constitution, that "the ratification of the conventions of 9 States" should suffice for its establishment between the States so ratifying the same. There was another reason, of a more general and perhaps more controlling character, for this reference to conventions for ratification, even if entire unanimity of the State legislatures could have been expected. Under the American theory of republican government, conventions of the people, duly elected and accredited as such, are invested with the plenary power inherent in the people of an organized and independent community, assembled in mass. In other words, they represent and exercise what is properly the sovereignty of the people. State legislatures, with restricted powers, do not possess or represent sovereignty. Still less does the Congress of a Union or Confederacy of States, which is by 2 degrees removed from the seat of sovereignty. We sometimes read or hear of delegated sovereignty, divided sovereignty, with other loose expressions of the same sort, but no such thing as a division or delegation of sovereignty is possible. In order, therefore, to supersede the restraining article above cited, and to give the highest validity to the compact for the delegation of important powers and functions of government to a common agent, an authority above that of the State legislatures was necessary. Mr. Madison, in The Federalist, says, "It has been heretofore noted among the defects of the Confederation that in many of the States it had received no higher sanction than a mere legislative ratification." This objection would, of course, have applied with greater force to the proposed Constitution, which provided for additional grants of power from the states, and the conferring of larger and more varied powers upon a general government which was to act upon individuals instead of states, if the question of its confirmation had been submitted merely to the several state legislatures. Hence the obvious propriety of referring it to the respective people of the states in their sovereign capacity, as provided in the final article of the Constitution. In this article, provision was deliberately made for the secession, if necessary, of a part of the states from a union which, when formed, had been declared perpetual, and its terms and articles to be inviolably observed by every state. Opposition was made to the provision on this very ground, that it was virtually a dissolution of the Union, and that it would furnish a precedent for future secessions. Mr. Gerry, a distinguished member from Massachusetts, afterward Vice President of the United States, said, "If 9 out of 13 states can dissolve the compact, 6 out of 9 will be just as able to dissolve the future one hereafter." Mr. Madison, who was one of the leading members of the convention, advocating afterwards in the Federalist the adoption of the new Constitution, asked the question, "On what principle the Confederation, which stands in the solemn form of a compact among the states, can be superseded without the unanimous consent of the parties to it?" He answers this question "by recurring to the absolute necessity of the case, to the great principle of self-preservation, to the transcendent law of nature and of nature's God, which declares that the safety and happiness of society are the objects at which all political institutions aim, and to which all such institutions must be sacrificed." He proceeds, however, to give other grounds of justification. "It is an established doctrine on the subject of treaties, that all the articles are mutually conditions of each other, that a breach of any one article is a breach of the whole treaty, and that a breach committed by either of the parties absolves the others, and authorizes them, if they please, to pronounce the compact violated and void. Should it unhappily be necessary to appeal to these delicate truths for a justification for dispensing with the consent of particular states to a dissolution of the federal pact, will not the complaining parties find it a difficult task to answer the multiplied and important infractions with which they may be confronted? The time has been when it was incumbent on us all to veil the ideas which this paragraph exhibits. The scene is now changed, and with it the part which the same motives dictate." Mr. Madison's idea of the propriety of veiling any statement of the right of secession until the occasion arises for its exercise, whether right or wrong in itself, is eminently suggestive as explanatory of the caution exhibited by other statesmen of that period, as well as himself, with regard to that delicate truth. The only possible alternative to the view here taken of the 7th article of the Constitution, as a provision for the secession of any 9 states, which might think proper to avail themselves of it, from union with such as should refuse to do so, and the formation of an amended or more perfect union with one another, is to regard it as a provision for the continuance of the old Union, or Confederation, under altered conditions, by the majority which should accede to them, with a recognition of the right of the recusant minority to withdraw, secede, or stand aloof. The idea of compelling any state or states to enter into or to continue in union with the others by coercion is as absolutely excluded under the one supposition as under the other, with reference to one state or a minority of states, as well as with regard to a majority. The article declares that "the ratification of the conventions of 9 states shall be sufficient for the establishment of this Constitution," not between all, but "between the states so ratifying the same." It is submitted whether a fuller justification of this right of the 9 states to form a new government is not found in the fact of the sovereignty of each of them, making them "a law unto themselves," and therefore the final judge of what the necessities of each community demand. Here, although perhaps in advance of its proper place in the argument, the attention of the reader may be directed to the refutation afforded by this article of the Constitution of that astonishing fiction which has been put forward by some distinguished writers of later date, that the Constitution was established by the people of the United States in the aggregate. If such had been the case, the will of a majority, duly ascertained and expressed, would have been binding upon the minority. No such idea existed in its formation. It was not even established by the states in the aggregate, nor was it proposed that it should be. It was submitted for the acceptance of each separately, the time and place at their own option, so that the dates of ratification did extend from December 7th, 1787, to May 29th, 1790. The long period required for these ratifications makes manifest the absurdity of the assertion that it was a decision by the votes of one people or one community, in which a majority of the votes cast determined the result. We have seen that the delegates to the Convention of 1787 were chosen by the several states as states. It is hardly necessary to add that they voted in the Convention, as in the Federal Congress, by states, each state casting one vote. We have seen also that they were sent for the sole and express purpose of revising the Articles of Confederation and devising means for rendering the Federal Constitution "adequate to the exigencies of government and the preservation of the Union," that the terms Union, United States, Federal Constitution, and Constitution of the Federal Government were applied to the old Confederation in precisely the same sense in which they were used under the new, that the proposition to constitute a national government was distinctly rejected by the Convention, that the right of any state or states to withdraw from union with the others was practically exemplified, and that the idea of coercion of a state or compulsory measures was distinctly excluded under any construction that can be put upon the action of the Convention. To the original copy of the Constitution, as set forth by its framers for the consideration and final action of the people of the States, was attached the following words: "Done in convention by the unanimous consent of the States present, the 17th day of September, in the year of our Lord 1787, and of the independence of the United States of America, the 12th, in witness whereof we have hereunto subscribed our names," followed by the signatures of George Washington, President, and deputy from Virginia, and the other delegates who signed it. This attachment to the instrument, a mere attestation of its authenticity, and of the fact that it had the unanimous consent of all the States then present by their deputies, not of all the deputies, for some of them refused to sign it, has been strangely construed by some commentators as if it were a part of the Constitution, and implied that it was done in the sense of completion of the work. But the work was not done when the convention closed its labors and adjourned. It was scarcely begun. There was no validity or binding force whatever in what had been already done. It was still to be submitted to the states for approval or rejection. Even if a majority of 8 out of 13 states had ratified it, the refusal of the ninth would have rendered it null and void. Mr. Madison, who was one of the most distinguished of its authors and signers, writing after it was completed and signed, but before it was ratified, said, quote, "It is time now to recollect that the powers of the convention were merely advisory and recommendatory, that they were so meant by the states and so understood by the convention, and that the latter have accordingly planned and proposed a constitution, which is to be of no more consequence than the paper on which it is written, unless it be stamped with the approbation of those to whom it is addressed." End quote. Federalist, number 40. The mode and terms in which this approval was expressed will be considered in the next chapter. End of chapter 2. Recording by Bill Moseley, Bernardo, Texas, USA. Section 13 of The Rise and Fall of the Confederate Government, Volume 1A. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Bill Moseley. The Rise and Fall of the Confederate Government by Jefferson Davis, Volume 1A, Part 2, Chapter 3. Ratification of the Constitution by the States. Organization of the new government. Accession of North Carolina and Rhode Island. Correspondence between General Washington and the Governor of Rhode Island. The amended system of union, or confederation, the terms are employed indiscriminately and interchangeably by the statesmen of that period, devised by the Convention of 1787, and embodied, as we have seen, in the Constitution which they framed and have set forth, was now to be considered and acted on by the people of the several states. This they did in the highest and most majestic form in which the sanction of organized communities could be given or withheld, not through ambassadors, or legislatures, or deputies with limited powers, but through conventions of delegates chosen expressly for the purpose and clothed with the plenary authority of sovereign people. The action of these conventions was deliberate, cautious, and careful. There was much debate and no little opposition to be conciliated. 11 states, however, ratified and adopted the new Constitution within the 12 months immediately following its submission to them. 2 of them positively rejected it, and although they afterward acceded to it, remained outside of the Union in the exercise of their sovereign right, which nobody then denied. North Carolina for 9 months, Rhode Island for nearly 15, after the new government was organized and went into operation. In several of the other states, the ratification was effected only by small majorities. The terms in which this action was expressed by the several states, and the declarations with which it was accompanied by some of them, are worthy of attention. Delaware was the first to act. Her convention met on December 3rd, 1787, and ratified the Constitution on the 7th. The readiness of this least in population, and next to the least in territorial extent, of all the states to accept that instrument is a very significant fact when we remember the jealous care with which she had guarded against any infringement of her sovereign statehood. Delaware alone had given special instructions to her deputies in the convention not to consent to any sacrifice of the principle of equal representation in Congress. The promptness and unanimity of her people in adopting the new Constitution proved very clearly not only that they were satisfied with the preservation of that principle in the Federal Senate, but that they did not understand the Constitution in any of its features as compromising the sovereignty, freedom, and independence which she had so especially cherished. The ratification of their convention is expressed in these words: "We, the deputies of the people of the Delaware State, in convention met, having taken into our serious consideration the Federal Constitution proposed and agreed upon by the deputies of the United States at a general convention held at the city of Philadelphia on the 17th day of September, A.D. 1787, have approved of, assented to, and ratified and confirmed, and by these presents do, in virtue of the powers and authority to us given for that purpose, for and in behalf of ourselves and our constituents, fully, freely, and entirely approve of, assent to, ratify, and confirm the said Constitution. Done in convention at Dover, December 7th, 1787." This and 12 other like acts gave to the Constitution all the life and validity it ever had or could have as to the 13 united or associated states. Pennsylvania acted next, December 12, 1787, the ratification not being finally accomplished without strong opposition, on grounds which will be referred to hereafter. In announcing its decision, the convention of this state began as follows: "In the name of the people of Pennsylvania, be it known unto all men that we, the delegates of the people of the Commonwealth of Pennsylvania, in general convention assembled," etc., etc., concluding with these words, "by these presents do, in the name and by the authority of the same people, and for ourselves, assent to and ratify the foregoing Constitution for the United States of America." In New Jersey, the ratification, which took place on the 18th of December, was unanimous. This is no less significant and instructive than the unanimity of Delaware, from the fact that the New Jersey delegation in the convention that framed the Constitution had taken the lead in behalf of the federal or state rights idea, in opposition to that of nationalism or consolidation. William Patterson, a distinguished citizen, afterward governor of New Jersey, had introduced into that convention what was known as the Jersey Plan, embodying these state rights principles as distinguished from the various national plans presented. In defending them, he had said, after calling for the reading of the credentials of delegates: "Can we, on this ground, form a national government? I fancy not. Our commissions give a complexion to the business. And can we suppose that, when we exceed the bounds of our duty, the people will approve our proceedings? We are met here as the deputies of 13 independent sovereign states, for federal purposes. Can we consolidate their sovereignty and form one nation, and annihilate the sovereignties of our states, who have sent us here for other purposes?" Again, on a subsequent day, after stating that he was not there to pursue his own sentiments of government, but of those who had sent him, he had asked: "Can we, as representatives of independent states, annihilate the essential powers of independency? Are not the votes of this convention taken on every question under the idea of independency?" The fact that this state, which, through her representatives, had taken so conspicuous a part in the maintenance of the principle of state sovereignty, ratified the Constitution with such readiness and unanimity, is conclusive proof that, in her opinion, that principle was not compromised thereby. The conclusion of her ordinance of ratification is in these words: "Now be it known that we, the delegates of the State of New Jersey, chosen by the people thereof, for the purpose aforesaid, having maturely deliberated on and considered the aforesaid proposed Constitution, do hereby, for and on behalf of the people of the said State of New Jersey, agree to, ratify, and confirm the same and every part thereof, done in convention by the unanimous consent of the members present, this 18th day of December, A.D. 1787. Georgia next, and also unanimously, on January 2nd, 1788, declared, through the delegates of the State of Georgia in convention met, pursuant to the provisions of the act of the legislature aforesaid, in virtue of the powers and authority given us them by the people of the said State for that purpose, that they did fully and entirely assent to, ratify, and adopt the said Constitution." Connecticut, on the 9th of January, declares her assent with equal distinctness of assertion as to the source of the authority. "In the name of the people of the State of Connecticut, we, the delegates of the people of the said State, in general convention assembled, pursuant to an act of the legislature in October last, do assent to, ratify, and adopt the Constitution reported by the convention of delegates in Philadelphia." In Massachusetts there was a sharp contest. The people of that State were then, as for a long time afterward, exceedingly tenacious of their State independence and sovereignty. The proposed Constitution was subjected to a close, critical, and rigorous examination, with reference to its bearing upon this very point. The convention was a large one, and some of its leading members were very distrustful of the instrument under their consideration. It was ultimately adopted by a very close vote, 187 to 168, and then only as accompanied by certain proposed amendments, the object of which was to guard more expressly against any sacrifice or compromise of State sovereignty, and under an assurance given by the advocates of the Constitution of the certainty that those amendments would be adopted. The most strenuously urged of these was that ultimately adopted, in substance, as the 10th Amendment to the Constitution, which was intended to take the place of the second Article of Confederation, as an emphatic assertion of the continued freedom, sovereignty, and independence of the States. This will be considered more particularly hereafter. In terms substantially identical with those employed by the other States, Massachusetts thus announced her ratification: "In convention of the delegates of the people of the Commonwealth of Massachusetts, 1788, the convention having impartially discussed and fully considered the Constitution for the United States of America reported, etc., do in the name and in behalf of the people of the Commonwealth of Massachusetts assent to and ratify the said Constitution for the United States of America." This was accomplished on February 7, 1788. Maryland followed on the 28th of April, and South Carolina on the 23rd of May, in equivalent expressions, the ratification of the former being made by the delegates of the people of Maryland, speaking, as they declared, for ourselves and in the name and on behalf of the people of this State; that of the latter in convention of the people of the State of South Carolina, by their representatives, in the name and behalf of the people of this State. But South Carolina, like Massachusetts, demanded certain amendments, and for greater assurance accompanied her ordinance of ratification with the following distinct assertion of the principle afterward embodied in the 10th Amendment: "This convention doth also declare that no section or paragraph of the said Constitution warrants a construction that the States do not retain every power not expressly relinquished by them and vested in the general government of the Union." The delegates of the people of the State of New Hampshire, in convention on the 21st of June, in the name and behalf of the people of the State of New Hampshire, declared their approval and adoption of the Constitution. In this State also the opposition was formidable, the final vote being 57 to 46; and, as in South Carolina, it was explicitly declared that all powers not expressly and particularly delegated by the aforesaid Constitution are reserved to the several States, to be by them exercised. The debates in the Virginia Convention were long and animated. Some of the most eminent and most gifted men of that period took part in them, and they have ever since been referred to for the exposition which they afford of the interpretation of the Constitution by its authors and their contemporaries. Among the members were Madison, Mason, and Randolph, who had also been members of the convention at Philadelphia. Mr. Madison was one of the most earnest advocates of the new Constitution, while Mr. Mason was as warmly opposed to its adoption. So also was Patrick Henry, the celebrated orator. It was assailed with great vehemence at every vulnerable or doubtful point, and was finally ratified June 26, 1788, by a vote of 89 to 79, a majority of only 10. This ratification was expressed in the same terms employed by other States, by the delegates of the people of Virginia, in the name and in behalf of the people of Virginia. In so doing, however, like Massachusetts, New Hampshire, and South Carolina, Virginia demanded certain amendments as a more explicit guarantee against consolidation, and accompanied the demand with the following declaration: "That the powers granted under the Constitution, being derived from the people of the United States, may be resumed by them, whenever the same shall be perverted to their injury or oppression, and that every power not granted thereby remains with them and at their will," etc., etc. Whether, in speaking of a possible resumption of powers by the people of the United States, the convention had in mind the action of such a people in the aggregate political community which did not exist, and of which they could hardly have entertained even an ideal conception, or of the people of Virginia, for whom they were speaking, and of the other United States then taking similar action, is a question which scarcely admits of argument, but which will be more fully considered in the proper place. New York, the 11th State to signify her assent, did so on July 26, 1788, after an arduous and protracted discussion, and then by a majority of but 3 votes, 30 to 27. Even this small majority was secured only by the recommendation of certain material amendments, the adoption of which by the other States it was at first proposed to make a condition precedent to the validity of the ratification. This idea was abandoned after a correspondence between Mr. Hamilton and Mr. Madison, and instead of conditional ratification, New York provided for the resumption of her grants. But the amendments were put forth with a circular letter to the other States, in which it was declared that nothing but the fullest confidence of obtaining a revision of the objectionable features of the Constitution, and an invincible reluctance to separating from our sister States could have prevailed upon a sufficient number to ratify it without stipulating for previous amendments. The ratification was expressed in the usual terms, as made by the delegates of the people of the State of New York, in the name and in behalf of the people of the said State. Accompanying it was a declaration of the principles in which the assent of New York was conceded, one paragraph of which runs as follows: that the powers of government may be reassumed by the people whensoever it shall become necessary to their happiness; that every power, jurisdiction, and right which is not, by the said Constitution, clearly delegated to the Congress of the United States, or the departments of the government thereof, remains to the people of the several States, or to their respective State governments, to whom they may have granted the same; and that those clauses in the said Constitution which declare that Congress shall not have or exercise certain powers, do not imply that Congress is entitled to any powers not given by the said Constitution, but such clauses are to be construed either as exceptions to certain specified powers, or as inserted for greater caution. The acceptance of these 11 States having been signified to the Congress, provision was made for putting the new Constitution in operation. This was effected on March 4th, 1789, when the government was organized with George Washington as President and John Adams Vice President, the senators and representatives elected by the States which had acceded to the Constitution organizing themselves as a Congress. Meantime, 2 States were standing, as we have seen, unquestioned and unmolested, in an attitude of absolute independence. The convention of North Carolina, on August 2nd, 1788, had rejected the proposed Constitution, or, more properly speaking, had withheld her ratification until action could be taken upon the subject matter of the following resolution, adopted by her convention: Resolved, that a declaration of rights, asserting and securing from encroachment the great principles of civil and religious liberty and the unalienable rights of the people, together with amendments to the most ambiguous and exceptionable parts of the said Constitution of Government, ought to be laid before Congress and the convention of the States that shall or may be called for the purpose of amending the said Constitution, for their consideration, previous to the ratification of the Constitution aforesaid, on the part of the State of North Carolina. More than a year afterward, when the newly organized government had been in operation for nearly 9 months, and when, although no convention of the States had been called to revise the Constitution, North Carolina had good reason to feel assured that the most important provisions of her proposed amendments and Declaration of Rights would be adopted, she acceded to the amended compact. On November 21st, 1789, her convention agreed, in behalf of the freemen, citizens, and inhabitants of the State of North Carolina, to adopt and ratify the Constitution. In Rhode Island, the proposed Constitution was at first submitted to a direct vote of the people, who rejected it by an overwhelming majority. Subsequently, that is, on May 29th, 1790, when the reorganized government had been in operation for nearly 15 months, and when it had become reasonably certain that the amendments thought necessary would be adopted, a convention of the people of Rhode Island acceded to the new Union, and ratified the Constitution, though even then by a majority of only 2 votes in 66, 34 to 32. The ratification was expressed in substantially the same language as that which has now been so repeatedly cited. We, the delegates of the people of the State of Rhode Island and Providence Plantations, duly elected and met in convention, in the name and behalf of the people of Rhode Island and Providence Plantations, do by these presents, assent to and ratify the said Constitution. It is particularly to be noted that, during the intervals between the organization of the Federal Government under the new Constitution and the ratification of that Constitution by North Carolina and Rhode Island, respectively, those States were absolutely independent and unconnected with any other political community, unless they be considered as still representing the United States of America, which, by the Articles of Confederation, had been declared a perpetual union. The other States had seceded from the former union, not in a body, but separately, each for itself, and had formed a new association, leaving these two States in the attitude of foreign though friendly powers. There was no claim of any right to control their action, as if they had been mere geographical or political divisions of one great consolidated community or nation. Their accession to the Union was desired, but their freedom of choice in the matter was never questioned. And then it is to be noted on their part that, like the house of Judah, they refrained from any attempt to force the seceding sisters to return. As illustrative of the relations existing during this period between the United States and Rhode Island, it may not be uninstructive to refer to a letter sent by the government of the latter to the President and Congress, and transmitted by the President to the Senate, with the following note: United States, September 26, 1789. Gentlemen of the Senate, having yesterday received a letter written in this month by the Governor of Rhode Island, at the request and in behalf of the General Assembly of that State, addressed to the President, the Senate, and the House of Representatives of the 11 United States of America in Congress assembled, I take the earliest opportunity of laying a copy of it before you. Signed, George Washington. Some extracts from the communication referred to are annexed. State of Rhode Island and Providence Plantations, in General Assembly, September Session, 1789. To the President, the Senate, and the House of Representatives of the 11 United States of America, in Congress assembled: The critical situation in which the people of this State are placed engages us to make these assurances on their behalf of their attachment and friendship to their sister States, and of their disposition to cultivate mutual harmony and friendly intercourse. They know themselves to be a handful, comparatively viewed, and although they now stand as it were alone, they have not separated themselves or departed from the principles of that Confederation, which was formed by the sister States in their struggle for freedom and in the hour of danger. Our not having acceded to or adopted the new system of government, formed and adopted by most of our sister States, we doubt not, has given uneasiness to them. That we have not seen our way clear to it, consistently with our idea of the principles upon which we all embarked together, has also given pain to us. We have not doubted that we might thereby avoid present difficulties, but we have apprehended future mischief. Can it be thought strange that, with these impressions, they, the people of this State, should wait to see the proposed system organized and in operation, to see what further checks and securities would be agreed to and established by way of amendments, before they could adopt it as a constitution of government for themselves and their posterity? We are induced to hope that we shall not be altogether considered as foreigners having no particular affinity or connection with the United States, but that trade and commerce, upon which the prosperity of this State much depends, will be preserved as free and open between this State and the United States as our different situations at present can possibly admit. We feel ourselves attached by the strongest ties of friendship, kindred, and interest to our sister States, and we cannot, without the greatest reluctance, look to any other quarter for those advantages of commercial intercourse which we conceive to be more natural and reciprocal between them and us. I am, at the request and in behalf of the General Assembly, your most obedient, humble servant. (Signed) John Collins, Governor. His Excellency the President of the United States. American State Papers, Volume 1, Miscellaneous. End of Part 2, Chapter 3. Recording by Bill Moseley, Llano, Texas, USA.
Section 14 of the Rise and Fall of the Confederate Government, Volume 1A. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Sean Stipsky. The Rise and Fall of the Confederate Government by Jefferson Davis, Volume 1A, Part 2, Chapter 4. The Constitution not adopted by one people in the aggregate. A great fallacy exposed. Mistake of Judge Story. Colonial relations. The United Colonies of New England. Other associations. Independence of communities traced from Germany to Great Britain, and from Great Britain to America. Mr. Everett's provincial people. Origin and continuance of the title United States. No such political community as the people of the United States. The historical retrospect of the last three chapters and the extracts from the records of a generation now departed have been presented as necessary to a right understanding of the nature and principles of the compact of 1787, on which depended the questions at issue in the secession of 1861 and the contest that ensued between the States. We have seen that the United Colonies, when they declared their independence, formed a league or alliance with one another as United States. This title antedated the adoption of the Articles of Confederation. It was assumed immediately after the Declaration of Independence, and was continued under the Articles of Confederation, the first of which declared that the style of this Confederacy shall be the United States of America, and this style was retained, without question, in the formation of the present Constitution. The name was not adopted as antithetical to, or distinctive from, Confederate, as some seem to have imagined. If it has any significance now, it must have had the same under the Articles of Confederation, or even before they were adopted. It has been fully shown that the States, which thus became and continued to be united, whatever form their union assumed, acted and continued to act as distinct and sovereign political communities. The monstrous fiction that they acted as one people in their aggregate capacity has not an atom of fact to serve as a basis. To go back to the very beginning, the British colonies never constituted one people. Judge Story, in his commentaries on the Constitution, seemed to imply the contrary, though he shrinks from a direct assertion of it, and clouds the subject by a confusion of terms. He says, "Now it is apparent that none of the colonies before the Revolution were, in the most large and general sense, independent and sovereign communities. They were all originally settled under and subjected to the British Crown." And then he proceeds to show that they were, in their colonial condition, not sovereign, a proposition which nobody disputed. As colonies, they had no claim and made no pretension to sovereignty. They were subject to the British Crown, unless, like the Plymouth colony, a law unto themselves, but they were independent of each other, the only point which has any bearing upon their subsequent relations. There was no other bond between them than that of their common allegiance to the government of the mother country. As an illustration of this may be cited the historical fact that when John Stark, of Bennington memory, was before the Revolution engaged in a hunting expedition in the Indian country, he was captured by the savages and brought to Albany, in the colony of New York, for a ransom. But, inasmuch as he belonged to New Hampshire, the government of New York took no action for his release. There was not even enough community of feeling to induce individual citizens to provide money for the purpose. There were, however, local and partial confederacies among the New England colonies, long before the Declaration of Independence. As early as the year 1643, a Congress had been organized of delegates from Massachusetts, Plymouth, New Haven, and Connecticut, under the style of the United Colonies of New England. The objects of this confederacy, according to Mr. Bancroft, were protection against the encroachments of the Dutch and French, security against the tribes of savages, the liberties of the gospel in purity and in peace. The general affairs of the company were entrusted to commissions, 2 from each colony, but the same historian tells us that to each its respective local jurisdiction was carefully reserved, and he refers to this as evidence that the germ principle of state rights was even then in existence. Thus remarkable for unmixed simplicity, he proceeds, was the form of the first confederated government in America. There was no president except as a moderator of its meetings, and the larger State, Massachusetts, superior to all the rest in territory, wealth, and population, had no greater number of votes than New Haven. But the commissioners were in reality little more than a deliberative body. They possessed no executive power, and, while they could decree a war and a levy of troops, it remained for the States to carry their votes into effect. This confederacy continued in existence for nearly 50 years. Between that period and the year 1774, when the First Continental Congress met in Philadelphia, several other temporary and provisional associations of colonies had been formed, and the people had been taught the advantages of union for a common purpose, but they had never abandoned or compromised the great principle of community independence. That form of self-government, generated in the German forests before the days of the Caesars, had given to that rude people a self-reliance and patriotism which first checked the flight of Roman eagles, which elsewhere had been the emblem of their dominion over the known world. This principle, the great preserver of all communal freedom and of mutual harmony, was transplanted by the Saxons into England, and there sustained those personal rights which, after the fall of the Heptarchy, were almost obliterated by the encroachments of Norman despotism, but, having the strength and perpetuity of truth and right, were reasserted by the male hands of the barons at Runnymede for their own benefit and that of their posterity. Englishmen, the early settlers, brought this idea to the wilds of America, and it found expression in many forms among the infant colonies. Mr. Edward Everett, in his 4th of July address, delivered in New York in 1861, following the lead of Judge Story, and with even less caution, boldly declares that, before their independence of England was asserted, they, the colonies, constituted a provincial people. To sustain this position, utterly contrary to all history as it is, he is unable to adduce any valid American authority, but relies almost exclusively upon loose expressions employed in debate in the British Parliament about the period of the American Revolution, such as that people, that loyal and respectable people, this enlightened and spirited people, etc., etc. The speakers who made use of this colloquial phraseology concerning the inhabitants of a distant continent, in the freedom of extemporaneous debate, were not framing their ideas with the exactitude of a didactic treatise, and could little have foreseen the extraordinary use to be made of their expressions nearly a century afterward, in sustaining a theory contradictory to history as well as to common sense. It is as if the familiar expressions often employed in our own time, such as the people of Africa or the people of South America, should be cited by some ingenious theorist of a future generation, as evidence that the subjects of the Khedive and those of the King of Dahomey were but one people, or that the Peruvians and the Patagonians belonged to the same political community. Mr. Everett, it is true, quotes 2 expressions of the Continental Congress to sustain his remarkable proposition that the colonies were a people. One of these is found in a letter addressed by the Congress to General Gage in October, 1774, remonstrating against the erection of fortifications in Boston, in which they say, "We entreat your Excellency to consider what a tendency this conduct must have to irritate and force a free people hitherto well disposed to peaceable measures, into hostilities. From this expression Mr. Everett argues that the Congress considered themselves the representatives of "a people." But, by reference to the proceedings of the Congress, he might readily have ascertained that the letter to General Gage was written in behalf of the town of Boston and province of Massachusetts Bay, the people of which were "considered by all America as suffering in the common cause for their noble and spirited opposition to oppressive acts of Parliament." The avowed object was "to entreat his Excellency, from the assurance we have of the peaceable disposition of the inhabitants of the town of Boston and of the province of Massachusetts Bay, to discontinue his fortifications." These were the people referred to by the Congress, and the children of the Pilgrims who occupied at that period the town of Boston and province of Massachusetts Bay would have been not a little astonished to be reckoned as one people, in any other respect than that of the common cause, with the Roman Catholics of Maryland, the Episcopalians of Virginia, the Quakers of Pennsylvania, or the Baptists of Rhode Island. The other citation of Mr. Everett is from the first sentence of the Declaration of Independence, when in the course of human events it becomes necessary for one people to dissolve the political bands which have connected them with another, etc., etc. This, he says, characterizes the good people of the colonies as one people. Plainly, it does no such thing. The misconception is so palpable as scarcely to admit of serious answer. The Declaration of Independence opens with a general proposition. One people is equivalent to saying any people. The use of the correlatives one and another was the simple and natural way of stating this general proposition. One people applies, and was obviously intended to apply, to all cases of the same category, to that of New Hampshire, or Delaware, or South Carolina, or any other people existing or to exist, and whether acting separately or in concert. It applies to any case and all cases of dissolution of political bands, as well as to the case of the British colonies. It does not, either directly or by implication, assert their unification, and has no bearing whatever upon the question. When the colonies united in sending representatives to a Congress in Philadelphia, there was no purpose, no suggestion of a purpose, to merge their separate individuality in one consolidated mass. No such idea existed, or, with their known opinions, could have existed. They did not assume to become a united colony or province, but styled themselves united colonies, colonies united for purposes of mutual counsel and defense, as the New England colonies had been united more than 100 years before. It was as United States, not as a state or united people, that these colonies, still distinct and politically independent of each other, asserted and achieved their independence of the mother country. As United States, they adopted the Articles of Confederation, in which the separate sovereignty, freedom, and independence of each was distinctly asserted. They were United States when Great Britain acknowledged the absolute freedom and independence of each, distinctly and separately recognized by name. France and Spain were parties to the same treaty, and the French and Spanish idioms still express and perpetuate, more exactly than the English, the true idea intended to be embodied in the title, Les États-Unis, or Los Estados Unidos, the States United. It was, without any change of title, still as United States, without any sacrifice of individuality, without any compromise of sovereignty, that the same parties entered into a new and amended compact with one another under the present Constitution. Larger and more varied powers were conferred upon the common government for the purpose of ensuring a more perfect union, not for that of destroying or impairing the integrity of the contracting members. The point which now specially concerns the argument is the historical fact that, in all these changes of circumstances and of government, there has never been one single instance of action by the people of the United States in the aggregate, or as one body. Before the era of independence, whatever was done by the people of the colonies was done by the people of each colony separately and independently of each other, although in union by their delegates for certain specified purposes. Since the assertion of their independence, the people of the United States have never acted otherwise than as the people of each State, severally and separately. The Articles of Confederation were established and ratified by the several States, either through conventions of their people or through the State legislatures. The Constitution which superseded those articles was framed, as we have seen, by delegates chosen and empowered by the several States, and was ratified by conventions of the people of the same States, all acting in entire independence of one another. This ratification alone gave it force and validity. Without the approval and ratification of the people of the States, it would have been, as Mr. Madison expressed it, of no more consequence than the paper on which it was written. It was never submitted to the people of the United States in the aggregate, or as a people. Indeed, no such political community as the people of the United States in the aggregate exists at this day or ever did exist. Senators in Congress confessedly represent the States as equal units. The House of Representatives is not a body of representatives of the people of the United States, as often erroneously asserted, but the Constitution, in the second section of its first article, expressly declares that it shall be composed of members chosen by the people of the several States. Nor is it true that the President and Vice President are elected, as it is sometimes vaguely stated, by vote of the whole people of the Union. Their election is even more unlike what such a vote would be than that of the Representatives, who in numbers at least represent the strength of their respective States. In the election of President and Vice President, the Constitution, Article II, prescribes that each State shall appoint, in such manner as the legislature thereof may direct, a number of electors, for the purpose of choosing a President and Vice President. The number of these electors is based partly upon the equal sovereignty, partly upon the unequal population of the respective States. It is, then, absolutely true that there has never been any such thing as a vote of the people of the United States in the aggregate. No such people is recognized by the Constitution, and no such political community has ever existed. It is equally true that no officer or department of the general government formed by the Constitution derives authority from a majority of the whole people of the United States, or has ever been chosen by such majority. As little as any other is the United States government a government of a majority of the mass. End of section 14. Recording by Sean Stipsky, Kingman, Arizona. Of the Rise and Fall of the Confederate Government, Volume 1A. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Sean Stipsky. The Rise and Fall of the Confederate Government by Jefferson Davis, Volume 1A, Part 2, Chapter 5. The Preamble to the Constitution, We the People. The preamble to the Constitution proposed by the Convention of 1787 is in these words: "We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America." The phraseology of this preamble has been generally regarded as the stronghold of the advocates of consolidation. It has been interpreted as meaning that we, the people of the United States, as a collective body, or as a nation, in our aggregate capacity, had ordained and established the Constitution over the States. This interpretation constituted, in the beginning, the most serious difficulty in the way of the ratification of the Constitution. It was probably this to which that sturdy patriot Samuel Adams of Massachusetts alluded when he wrote to Richard Henry Lee, "I stumble at the threshold." Patrick Henry, in the Virginia Convention on the third day of the session, and in the very opening of the debate, attacked it vehemently. He said, speaking of the system of government set forth in the proposed Constitution, that this is a consolidated government is demonstrably clear, and the danger of such a government is, to my mind, very striking. I have the highest veneration for those gentlemen, its authors, but, sir, give me leave to demand, what right had they to say, "We the people"? My political curiosity, exclusive of my anxious solicitude for the public welfare, leads me to ask, who authorized them to speak the language of "we the people" instead of "we the States"? States are the characteristics in the soul of a confederation. If the States be not the agents of this compact, it must be one great consolidated national government of the people of all the States. Again, on the next day, with reference to the same subject, he said: "When I asked that question, I thought the meaning of my interrogation was obvious. The fate of this question and of America may depend on this. Have they said 'we the States'? Have they made a proposal of a compact between States? If they had, this would be a confederation. It is otherwise most clearly a consolidated government. The question turns, sir, on that poor little thing, the expression 'we the people' instead of 'the States of America.'" The same difficulty arose in other minds and in other conventions. The scruples of Mr. Adams were removed by the explanations of others, and by the assurance of the adoption of the amendments thought necessary, especially of that declaratory safeguard afterward embodied in the Tenth Amendment, to be referred to hereafter. Mr. Henry's objection was thus answered by Mr. Madison: "Who are the parties to it (the Constitution)? The people, but not the people as composing one great body, but the people as composing 13 sovereignties. Were it, as the gentleman Mr. Henry asserts, a consolidated government, the assent of a majority of the people would be sufficient for its establishment, and, as a majority have adopted it already, the remaining States would be bound by the act of the majority, even if they unanimously reprobated it. Were it such a government as is suggested, it would be now binding on the people of this State, without having had the privilege of deliberating upon it. But, sir, no State is bound by it, as it is, without its own consent. Should all the States adopt it, it will be then a government established by the 13 States of America, not through the intervention of legislatures, but by the people at large. In this particular respect, the distinction between the existing and proposed governments is very material. The existing system has been derived from the dependent, derivative authority of the legislatures of the States, whereas this is derived from the superior power of the people. It must be remembered that this was spoken by one of the leading members of the Convention which formed the Constitution, within a few months after that instrument was drawn up. Mr. Madison's hearers could readily appreciate his clear answer to the objection made. The people intended were those of the respective States, the only organized communities of people exercising sovereign powers of government, and the idea intended was the ratification and establishment of the Constitution by direct act of the people in their conventions, instead of by act of their legislatures, as in the adoption of the Articles of Confederation. The explanation seems to have been as satisfactory as it was simple and intelligible. Mr. Henry, although he fought to the last against the ratification of the Constitution, did not again bring forward this objection, for the reason, no doubt, that it had been fully answered. Indeed, we hear no more of the interpretation which suggested it from that period for nearly half a century, when it was revived and has since been employed to sustain that theory of a great consolidated national government which Mr. Madison so distinctly repudiated. But we have access to sources of information not then available, which make the intent and meaning of the Constitution still plainer. When Mr. Henry made his objection and Mr. Madison answered it, the Journal of the Philadelphia Convention had not been published. That body had sat with closed doors, and among its rules had been the following: that no copy be taken of any entry on the Journal during the sitting of the House without the leave of the House; that members only be permitted to inspect the Journal; that nothing spoken in the House be printed or otherwise published or communicated without leave. We can understand, by reference to these rules, how Mr. Madison should have felt precluded from making allusion to anything that had occurred during the proceedings of the Convention. But the secrecy then covering these proceedings has long since been removed. The manuscript journal, which was entrusted to the keeping of General Washington, the President of the Convention, was deposited by him 9 years afterward among the archives of the State Department. It has since been published, and we can trace for ourselves the origin and ascertain the exact significance of that expression, "we the people," on which Patrick Henry thought the fate of America might depend, and which has been so grossly perverted in later years from its true intent. The original language of the preamble, reported to the Convention by a committee of 5 appointed to prepare the Constitution, as we find it in the proceedings of August 6, 1787, was as follows: "We, the people of the States of New Hampshire, Massachusetts, Rhode Island and Providence Plantations, Connecticut, New York, New Jersey, Pennsylvania, Delaware, Maryland, Virginia, North Carolina, South Carolina, and Georgia, do ordain, declare, and establish the following Constitution for the government of ourselves and our posterity." There can be no question here what was meant. It was the people of the States, designated by name, that were to ordain, declare, and establish the compact of union for themselves and their posterity. There is no ambiguity nor uncertainty in the language, nor was there any difference in the Convention as to the use of it. The preamble, as perfected, was submitted to vote on the next day, and, as the Journal informs us, it passed unanimously in the affirmative. There was no subsequent change of opinion on the subject. The reason for the modification afterward made in the language is obvious. It was found that unanimous ratification of all the States could not be expected, and it was determined, as we have already seen, that the consent of 9 States should suffice for the establishment of the new compact between the States so ratifying the same. Any 9 would be sufficient to put the proposed government in operation as to them, thus leaving the remainder of the 13 to pursue such course as might be to each preferable. When this conclusion was reached, it became manifestly impracticable to designate beforehand the consenting States by name. Hence, in the final revision, the specific enumeration of the 13 States was omitted, and the equivalent phrase "people of the United States" inserted in its place, plainly meaning the people of such States as should agree to unite on the terms proposed. The imposing fabric of political delusion which has been erected on the basis of this simple transaction disappears before the light of historical record. Could the authors of the Constitution have foreseen the perversion to be made of their obvious meaning, it might have been prevented by an easy periphrasis, such as "we, the people of the United States, hereby united," or something to the same effect. The word "people" in 1787, as in 1880, was, as it is, a collective noun, employed indiscriminately, either as a unit in such expressions as "this people," "a free people," etc., or in a distributive sense as applied to the citizens or inhabitants of one State or country, or a number of States or countries. When the Convention of the Colony of Virginia in 1774 instructed their delegates to the Congress that was to meet in Philadelphia to obtain a redress of those grievances, without which the people of America can neither be safe, free, nor happy, it was certainly not intended to convey the idea that the people of the American continent, or even of the British colonies in America, constituted one political community. Nor did Edmund Burke have any such meaning when he said in his celebrated speech in Parliament in 1775, "The people of the colonies are descendants of Englishmen." We need to go no further than to the familiar language of King James's translation of the Bible for multiplied illustrations of this indiscriminate use of the term, both in its collective and distributive senses. For example, King Solomon prays at the dedication of the temple, "that thine eyes may be open unto the supplication of thy people Israel, to hearken unto them in all that they call for unto thee. For thou didst separate them from among all the people of the earth to be thine inheritance." 1 Kings chapter 8, verses 52 and 53. Here we have both the singular and plural senses of the same word, one people, Israel, and all the people of the earth, in 2 consecutive sentences. In the people of the earth, the word people is used precisely as it is in the expression the people of the United States in the preamble to the Constitution, and has exactly the same force and effect. If in the latter case it implies that the people of Massachusetts and those of Virginia were mere fractional parts of one political community, It must, in the former, imply a like unity among the Philistines, the Egyptians, the Assyrians, the Babylonians, and the Persians, and all other people of the earth, except the Israelites. Scores of examples of the same sort might be cited if it were necessary. In the Declaration of Independence we find precisely analogous instances of the employment of the singular form for both singular and plural senses: one people, a free people, in the former, and the good people of these colonies in the latter. Judge Story, in the excess of his zeal in behalf of a theory of consolidation, bases upon this last expression the conclusion that the assertion of independence was the act of the whole people of the United Colonies as a unit, overlooking or suppressing the fact that in the very same sentence the colonies declare themselves free and independent states, not a free and independent state, repeating the words independent states 3 times. If, however, the Declaration of Independence constituted one whole people of the colonies, then that geographical section of it, formerly known as the colony of Maryland, was in a state of revolt or rebellion against the others, as well as against Great Britain, from 1778 to 1781, during which period Maryland refused to ratify or be bound by the Articles of Confederation, which, according to this theory, was binding upon her, as a majority of the whole people had adopted it. A fortiori, North Carolina and Rhode Island were in a state of rebellion in 1789-90, while they declined to ratify and recognize the Constitution adopted by the other 11 fractions of this united people. Yet no hint of any such pretension, of any claim of authority over them by the majority, of any assertion of the supremacy of the Union is to be found in any of the records of that period. It might have been unnecessary to bestow so much time and attention in exposing the absurdity of the deductions from a theory so false, but for the fact that it has been specious enough to secure the countenance of men of such distinction as Webster, Story, and Everett, and that it has been made the plea to justify a bloody war against the principle of State sovereignty and independence, which was regarded by the fathers of the Union as the cornerstone of the structure and the basis of the hope for its perpetuity. End of section 15. Recording by Sean Stipsky, Kingman, Arizona.